What is judicial activism? Moderates and liberals like to claim that the term judicial activism is used when conservatives do not like a ruling made by a court. This might be true of them, but not of conservatives. When conservatives use the term judicial activism, it's when a decision was made by 1. Ignoring the original intent of a law or amendment, 2. Ignoring the historical practices of society after a law or amendment was put into effect, 3. Incorporating or letting foreign law influence a decision, 4. Expanding the meaning of laws or amendments by finding new principles, or 5. The new fifth way, made up by Supreme Court Justice Roberts, to change the meaning of words written in the law or amendment. Those who use judicial activism do it to bypass the legislative process. The best example of this can be found in the 2008 Supreme Court ruling, District of Columbia v. Heller, about the meaning of the Second Amendment. Does the Second Amendment mean that people can own and bear arms, or does it mean that only the state's militias can own guns? When one considers that our founding fathers did not go around taking away people's guns after writing the Constitution, or that people have always had the right to own guns since the Constitution, then it becomes easy for anyone to see the judicial activism of the 4 liberal judges on the court: Stevens, Souter, Ginsburg, and Breyer. They ignored the historical practices of society after the Second Amendment was passed, just so they could push their dream of a gunless society without going through the amendment process, which is also part of the legislative process. The continued judicial activism is going to kill our democratic process, because one of the things that helps keep the peace in America is that people can come together. Religious people and secular people, with all of their moral beliefs and different opinions, to form a consensus and vote on laws that decide which standards we are to live under. The majority can be satisfied that their standards won the day. The minority can take solace in the hope that in the future they can convince a majority of their fellow Americans that their standards are better. The legislature is where we fight these bloodless battles for the soul of our country. But what good is it to spend time and money building a consensus to pass laws if judges, because of their own personal and political persuasion, can easily and without conscience impose their will by judicial activism,